should this court's holding in Betts v. Brady, 316 U.S. 455, be reconsidered? The question, of course, is the right of accused in state criminal proceedings to the appointment of counsel. Specifically, in the present case that you have before you, the question is an exceedingly narrow one. The question in the present case is whether request being made by the accused that counsel be appointed to him, the accused being concededly indigent, it is the duty of the state to accede to that request and to appoint counsel for purposes of assisting the accused in the trial of the case. In other words, the present case involves a trial, a plea of not guilty. It involves a felony, and that is the narrow question that this case presents.
In 1963, a witness reported that he had seen Clarence Earl Gideon at a pool room in Florida at around 5:30 that morning, leaving with a wine bottle and money in his pockets. Based on this accusation alone, the police arrested Gideon and charged him with breaking and entering with intent to commit petty larceny. At his trial, Gideon requested the judge appoint him a lawyer since he could not afford one himself. The judge responded by telling Gideon that his conviction didn't allow him to receive legal counsel. At this time, Florida law dictated that lawyers were only provided for defendants in capital cases. Gideon was charged with breaking and entering with the intent to commit a misdemeanor, a federal offense. Gideon tried his best to defend himself throughout the case, making an opening statement to the jury, cross-examining the prosecution's witnesses, presenting witnesses in his own defense, declining to testify himself, and making arguments emphasizing his innocence. Although he tried his best, Gideon was a man with an 8th grade education. He had been in and out of crime his whole life and had no idea how to win a court case. Despite his best efforts, Gideon was found guilty and sentenced to 5 years in prison. This was a common trend in courts and part of the reason why the number of poor defendants convicted so greatly outnumbered those who could afford professional legal representation. Even though he was convicted, Gideon was sure he had received an unfair trial. From prison, he tried to learn as much as he could about the court system to more fully understand his trial and why he was denied legal aid. Using the information he culminated from books and other inmates, he filed a petition for writ of habeas corpus to the Florida Supreme Court. He was trying to challenge his conviction and sentence on the grounds that the judge's refusal to appoint counsel violated Gideon's constitutional rights. The Florida Supreme Court denied Gideon's initial petition. Even though his request was denied, Gideon kept pushing for justice. Next, he filed a handwritten petition to the Supreme Court of the United States. The court agreed to hear Gideon's case. They were ready to resolve the question of whether or not the right to counsel, guaranteed under the Sixth Amendment of the Constitution, applies to defendants in state courts. The ruling was unanimously in favor of Gideon. The court held that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial, and as such, applies to the states through the Due Process Clause of the 14th Amendment. When analyzing this case, one question that comes to mind is to what extent did the Gideon v. Wainwright case improve social equity within the American judicial system? We can evaluate this question in regard to many different social science perspectives, most importantly through the political, economic, and sociological perspectives. This is not the first time the Supreme Court has seen issues relating to the application of the Sixth Amendment. The amendment states, In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial and have the assistance of counsel for his defense. In the following years, the Supreme Court has heard several cases debating the extent to which poor criminal defendants have the right to a lawyer at public expense, and just how involved do their lawyers actually need to be. One of the most notable of these cases is the monumental Betts v. Brady in 1942. In this case, the judge held that the refusal to appoint counsel for a poor defendant charged with a felony in state court did not necessarily violate the Due Process Clause of the 14th Amendment. The court saw this issue even before that, too, in Powell v. Alabama in 1932. This case involved 9 black youths accused of raping 2 white women. Alabama law required the appointment of counsel in capital cases, but the attorneys did not consult with their clients and had done little more than show up to represent them at trial. Officials sprinted through the legal proceedings. A total of 3 trials took 1 day, and all 9 were sentenced to death. These are only 2 examples of past injustices in the process of trials, all of which were overturned in Gideon v. Wainwright. The biggest opposition to this ruling came from those concerned with the potential economic ramifications of the new system. This is a valid concern, keeping in mind the fact that after this, the amount of legal aid needed to be appointed is considerably magnified. There are roughly 30,000 felony prosecutions per year nationally and 5 million misdemeanor prosecutions a year. Before this case, each state had a different policy on which type of cases qualified for appointed legal representation. Now, because every state has to provide legal representation for every type of case, the number of lawyers they provide is greatly increased. Today, many defenders struggle under excessive caseloads and lack of adequate funding and independence, making it impossible for them to meet their legal and ethical obligations to represent their clients effectively. Additionally, many criminal defendants lack the basic right to vote if they have been convicted of a prior felony. As a result, there is little political incentive for legislators to reach beyond a very modest level of funding. In fact, only about 3% of money spent annually on criminal justice goes toward indignant defense. However, officials have taken into account these serious concerns and created systems that reimburse private attorneys who represent poor defendants. Many of these attorneys are paid through various tax-supported public defendant systems, charitably supported legal aid systems, or the appointment ad hoc of private attorneys. Sociologically, Gideon v. Wainwright did a lot to increase America's scope of individual liberty through the right to counsel. This case was successful in making the poor less vulnerable, therefore providing a more egalitarian system of administering justice to Americans than had previously existed. Allowing representation of counsel in all cases permits the indignant an equal opportunity to have a fair trial in a court of law. Typically, those who cannot afford a lawyer are likely to lack the necessary legal understanding to represent themselves in court, and therefore have a higher chance of being convicted, such as Gideon was. The system before Gideon offered non-equal treatment of defendants with regard to the appointment of counsel. Some example of aspects that became circumstances to which the doctrine in Betts v. Brady was applied were the age of the defendant, the complexity of his defense, and even the atmosphere of the courtroom. Betts v. Brady also created friction between the state and federal courts, because it did not provide an exact standard for the state courts to follow in regards to appointing legal counsel. This led to a disparity between the defendant's treatment before the court when asking to have counsel represent them. Gideon v. Wainwright offered a clear standard for all state courts to follow, that the Sixth Amendment guarantees the defendants the right to counsel in all criminal prosecutions. This case did more than just affect how much America spends on our court system. It drastically changed how people are tried and treated. Gideon v. Wainwright paved the way for the right to appointed counsel extending to misdemeanor and juvenile proceedings. Additionally, the Justice Department now provides a number of tools and resources to help establish effective indignant defense systems across the nation. In 2010, the department also launched the Office for Access to Justice, establishing a new permanent office focused on enhancing access to criminal and civil legal services for those who cannot afford them. The Supreme Court's recognition in Gideon that lawyers in criminal courts are necessities, not luxuries, and its guarantee of the right to counsel in the state criminal process has had a profound impact on the operation and aspirations of the American criminal justice system.